Let me just quote you to show you the evidence for this, a couple of sentences in his book, because to him it doesn't matter. It doesn't matter what the Constitution says about divisions of power between Congress and the President. He says, in fact, that large militaries designed to project overwhelming force throughout the world at his disposal, the President, as Commander-in-Chief, holds the initiative to use force abroad. Congress can always cut off funding for military adventures. Highly unlikely is an interpolation there. This effective check on the President's power renders unnecessary any formal process requirement for congressional authorization or a declaration of war before hostilities may begin.
If there is conflict underway, do you think that Congress will expose American troops by defunding them to what would essentially be certain death by removing material, armor, what have you, right? There are 535 members in the body. It can't do anything, let alone defund a war, especially when you consider, this is a little bit outside the four corners of the discussion, but the two-party duopoly and the idea that either party aspires to majority status so neither can actually accept a comfortably minority position, right? This is the dynamic that has everybody racing to the supposedly moderate middle that gets skewed to the right by Fox News. But the notion here that Congress does not, in fact, have an effective opportunity to defund war, to whatever extent that opportunity formalistically exists, it is certainly not sufficient to render any further process unnecessary.
If the President deems that he's got to torture somebody, including crushing the testicles of the person's child, there is no law that can stop that. No treaty. And also no law by Congress. That's what you wrote in the August 2002 memo. I think it depends on why the President thinks he needs to do that.
My response is going to be a little more visceral than intellectual, because I am a mother of boys, a grandmother of 2 boys, and the thought of this monster saying that it's okay to crush the testicles of children to get what this demented regime wants, to me, is reprehensible. John used skewed and extra-legal justification for torture, did nothing to protect this nation, nor the soldiers in the field. Almost the same day my son was killed in Iraq, in April of 2004, we started to see the images from Abu Ghraib on the news here. But trust me, the people of Iraq and Afghanistan knew this so-called beacon of freedom was sending its thugs to torture and kill with impunity. Exactly. Long before we heard of it here in the States. I'm going to talk a little bit about how John Yoo, a lawyer, appears to have very little faith in our American judicial system. Basically what he says is that we're at war with Al-Qaeda, and we cannot rely on our judicial system in any way, shape, or form. We must use his extreme ideas of the law.
And that, I think it's bad because it forces us to stop questioning terrorists. It forces us to provide a lot of intelligence about terrorists in the courtroom, and worst of all, it's going to force our soldiers and agents in the field, on the battlefield, to follow law enforcement and police rules when they should be fighting. So I would prefer that the trial be moved back to Guantanamo Bay.
There's been an amazing number of books written about this whole the torture memos and the whole torture regime that basically comes from Dick Cheney and Addington, and so they call themselves the War Council. And if you read a lot of these documents, it is all about torture. It is about basically not respecting our judicial system. As Ann was talking, Angela, earlier, we have these treaties. They have been our treaties for hundreds of years, or at least tens of decades or whatever, depending on the particular treaty. We have obligations under these international treaties. But Addington and John Yoo, they are of the school ideologically to basically wipe out any U.S. deference towards international law, towards these conventions, towards these treaties. There's a hatred of the United Nations. This is all about empire. This is what happened to the British, actually. To have this professor still be teaching is really appalling and outrageous. Chris Edley, was on a transition team for Obama. And it's not an accident. It's that the Justice Department, the Inspector General of the Justice Department, wrote report where John Yoo was supposed to be found guilty of misconduct, along with Jay Bybee and these other lawyers who were part of that torture memo writing.
Hello, thank you everybody. I came all the way over from London just to stand here to complain about John Yoo. I was asked just to say a few words really about John Yoo's defense of the military commissions at Guantanamo. Because he was part of this war council that we heard about, of these men around Dick Cheney. And it was Dick Cheney and David Arrington, I think in particular, who drove this notion of reviving military commissions to try people at Guantanamo. Well, these were set up in November 2001, and they were set up to launder torture information so that we could dispense with due process and justice for people who were tried at Guantanamo. Unfortunately, what happened was that when the military was assigning defense attorneys, these people, almost to a man and woman, realized that what they were being asked to do was illegal, and they fought very hard against it. And it took a long time until the Supreme Court came to decide about the military commissions and ruled them illegal in June 2006. The crimes that they are trying to prosecute people for are not war crimes at all. So what we need to be doing is getting back to the understanding that the only place to prosecute people who are accused of terrorist-related crimes is in federal court.
What struck me is that with the war on terrorism, not so much the war in Iraq, which is a sort of standard nation-state war, but in the war on terrorism, you had a situation where this is a new kind of enemy, and the conflict is different. And people within the executive branch were very reluctant to ask, well, really, do the rules that we have developed for the kinds of wars we know, the wars between nation states covered by the Geneva Conventions, do they really apply here or not? And people did not want to think about that question.
You know, when the framers wrote the Constitution, they understood that sometimes people act as part of a nation state, and they engage in wars on behalf of a nation state when they're wearing a uniform and they have a chain of command. And other times, people act outside the bounds of a nation. And in the time that the Constitution was written, they were called pirates. Pirates are people that don't wear uniforms, that aren't aligned with any states, and under our modern interpretation would be called terrorists. So if you recall earlier, I said that one of the provisions specifically granted to Congress in the Constitution is the right to control piracy. So our founders understood that sometimes people fight on behalf of nations, and sometimes people act without a nation, telling them what to do. And both of them were covered in the Constitution.
And I think the Constitution has a flexible process. Either branch can act on its own, take the initiative. Also means either branch can try to stop the other branch using its own powers, and that there's nothing wrong with that, that the constitutional system actually anticipates, if not intends, that there to be some conflict between the executive and legislative branches, between the president and Congress over something like war. But what I didn't think it was this kind of legalistic process where, like passing a law. And I think that makes sense because that would make the most sense if you had the other elements that you mentioned, that you had a world that was dangerous. You would want the government to be able to act flexibly and quickly if it needed to. If future challenges were going to be uncertain, you would want to have, again, an executive can take...
Underlying, his role in terms, he and Bybee's role in writing these memos was to give protection to all those people that have committed, obviously, these war crimes, because they don't want to end up like Pinochet. Remember Pinochet in London? Pinochet ultimately, years later, was caught because of these conventions against torture and because of these international treaties. And then he was sent, so that is why, that is the reason. They are afraid that they are going to be ultimately charged with war crimes. So they wrote these memos to cover themselves up. So all these are bogus, sham arguments.
We're going to have another clip from John Yoo, and we're going to have two law students respond. Yanine Seneshai and Raymond Buhlman. Raymond he's graduated from law school, and he's actually getting an LLM here at Bolt, which is an advanced law degree in constitutional law. And Yanin is the chair of the Bolt Alliance to Abolish Torture and a member of the National Lawyers Guild, and a 2L here.
Presidents are, by the Constitution,
This is a
required to protect the
demonstration
nation
of
from attack. That's their number one duty. And what I worry about with this president is he's not fully using the powers of the president at war. I think it's almost in this administration's DNA to think of terrorism as a law enforcement problem and to think of terrorism as a crime and not to think of it as an act of war.
Hey folks, my name is Yanine. I'm a second-year law student at Bolt. Thank you all for being here. I love what you've done to this construction site. It looks so awesome. So, law students are known for talking too much. I just have one thing to say. John Yoo proclaims that he's a strict constructionist. I don't know what he's talking about right here because he's inserting language in the Constitution I just don't recognize. And I took constitutional law last year.
Amen to that. So, first of all, I'd like to respond to one of John Yoo's earlier arguments. The idea of terrorism constituting a new threat. We live in a post-9/11 world. Well, the 1919 Paris Peace Conference, which occurred after the end of World War I, there was a list of war crimes that was published, about 20 of them. And the second crime on the list was torture. The third crime on the list was terrorism directed towards civilian populations. So terrorism was considered a war crime long before September 11th. Everybody recognized that. There's nothing new about the threat. There was no reason to change the way the law operates. It's sufficient. And in response to all of these arguments, the students at this university, and specifically Amnesty International at Berkeley, have organized a petition to reform the federal torture statute so that the United States finally perfectly and fully implements the Convention Against Torture. Because right now, torture is not explicitly a federal offense when it's committed within the United States. And we want to change that. Yes, indeed, it is very offensive. And it's undemocratic. And it goes against everything that the law stands for and for everything that humans should stand for. It is inhumane. In writing his memo, he violated 18 U.S.C. Section 373 in inducing a member of the CIA to commit an act of assault in saying that waterboarding was legal. Look it up. The law provides that the First Amendment is not a defense. You cannot write an order saying, hey, go torture somebody, and use the First Amendment as a defense. And the fact that he didn't use the word torture doesn't matter, because he knew exactly what he was doing. I have too much respect for John Yoo's intelligence to think that he was so dumb that he didn't understand that waterboarding is torture. So I am going to say what too many students do not say, that John Yoo should not be working here. He should be prosecuted.